Good morning. Hello. For those that don't know me, my name is Darren Redmayne, and I'm the Chief Executive of Lincoln Pensions. Welcome to our webinar, which is titled "To Defer or Not to Defer," and I guess that is the question. And certainly, it's a question and topic that is arising more and more as schemes and sponsors work through this Corona crisis together. Thank you for making the time to listen to us today. We hope you find the session productive, and we hope you're staying safe and well. So by way of introduction, we're in unfamiliar waters here. Parallels exist though, the financial crisis to an extent, and also all the IRM planning and contingency planning that a number of schemes have done over many years have looked at what would happen if extreme IRM events occur. This is one of those. We didn't know that it would be of this type or variety of crisis, but at least there are approaches and ways to think through the problem. Schemes are effectively now being asked to help finance sponsors, and therefore the question is being raised in discussions as to whether or what schemes should be getting, if anything, in return for that. Recent guidance from the regulator at the end of March has come out, trying to help stakeholders think through the problem. As we'll show, although the guidance was no doubt very well intended, it can be read and interpreted by different stakeholders in ways that may be helpful to the way they're viewing the world at the moment, and how to integrate those thoughts and guidance into the other guidance issued by the regulator poses some potential challenges, which we hope to try and look at as well. Recently, on a case that I was working on, it was suggested to me that market practice was to defer, and that was broadly what was happening in the market. I would say to those joining our webinar today that there isn't a market standard currently, that we and yourselves joining our webinar, that is being developed in real time on real life cases as we speak. And one of the reasons we wanted to hold today's webinar was to share in real time our own experiences so that we can help contribute to setting and establishing market practice. And with that in mind, we actually have worked on a flowchart and an approach to think through some of the challenges and the questions that the deferral requests give rise to. And during the course of the next week, we'll send out to every participant on this webinar a handout, a takeaway, which covers in a single sheet a flow and approach to thinking through some of these issues. So we hope you find the webinar helpful. I'm going to move on and talk about the speakers that are going to present over the next 30 or so minutes, and hopefully we'll then have time for 10 or 15 minutes of questions. So I'm going to pass in a moment to Alex Beecraft. Alex is a director within Lincoln Pensions. He has had a secondment previously to the pensions regulator, and he will be thinking through and sharing thoughts on how to look at the latest guidance that's been issued by the regulator and how to integrate that with some of the themes and guidance that's been previously issued. Alex will then pass to Emily Goodridge, another director at Lincoln Pensions in the team, and she is going to share with the group some of the practical cases, clearly on a no-names basis, and some of the learnings from those cases. And finally, Dan Mindell, and managing director here, who works with stressed and restructuring cases primarily, he will introduce and talk through some of the range of protections that we are seeking on behalf of clients, and at least considering when working on cases. Case experience that the number of requests is quite significant, and it's from a broad range of sponsors, and it ranges from those that have received requests and then principally just agree to them, to those that are in the midst right now of thinking through how to deal with them. So I'll now pass on to Alex Beecraft, who will talk through the regulatory perspective. Thank you.
Thank you, Darren, and good morning, everyone. So as Darren said, in this section, I will provide a high-level summary of some of the guidance that has come out of the pensions regulator over the last few weeks, and have a think about actually, well, how does that sit alongside existing guidance and trustees' existing requirements for their duties. So the regulator put out essentially two bits of guidance. The first came out on the 20th of March, very much initial thoughts, and then subsequently on the 29th of March, some more detailed considerations came out. Now this covered a range of issues relating to COVID, investment matters, transfer matters, guidance for trustees in the middle of valuations, but specifically in the context of this webinar today, some guidance for trustees on how to assess deficit reduction contribution deferral requests. Now, as ever with the regulator's guidance, and this is not a slight on the regulator, it's a difficult job. How you read that guidance may depend very much on your standpoint. And just to illustrate this, one of my colleagues prepared what you see on your screens now, which is essentially the same text, but with certain different segments highlighted to reflect how employers might look at the guidance versus how trustees might look at it. And I think it's quite clear from that actually you can read it quite differently, and maybe that explains some of the different views that we're hearing in the market at the moment. So it's always just a question with the regulator of how you read that guidance. But the core points in there are very sensible. But before we get into that, I thought we'd run another poll, and hopefully the technology will let us do that this time. So the poll, which hopefully now will come up onto your screen, which is, which of the following do you believe will be the most difficult aspect for trustees to consider when facing one of these requests? If you could vote now, and hopefully we'll get the results in just a second. Okay, so I don't know if we're able to see the results just yet. There we go. So pretty even split across the board there. So we've got about a quarter each about the need for a deferral. We'll come on to that very shortly, and also on suitable protections. And Dan and Emily will cover that later in the webinar. But I think the middle one there, nearly half the vote on ensuring the scheme is being treated equitably, brings us quite nicely actually onto the regulator's guidance, because I think that's the first key topic for the regulator. And this is something that, of course, the regulator has been pushing out there for a number of years, is that schemes must ensure they've been treated equitably. Now, very much in this situation, and we are seeing this across a range of sponsors, returns to shareholders, dividends, share buybacks should be stopped, whilst any deficit deferral discussions are ongoing. But it's also worth thinking not just about dividends, but more broadly about group flows of capital. So particularly trying to avoid situations where cash is being taken out of sponsors, even if an intercompany balance is being left there. It's actually trying to keep hold of that cash wherever possible. So it's worth thinking about that as well. Clearly, the regulator is keen that banks continue to be supportive of sponsors if schemes are being asked to do the same. And more generally, any other creditors out there, it's actually for trustees to understand how that pain is being shared amongst all the creditors. The second point there is that information is, as ever, key when making these decisions. Obviously, in the current scenario, which is changing as rapidly as it is quite difficult for sponsors to take much a review about what anything beyond the immediate future might look like. And I think that's got to be understood and appreciated. But at the same time, to the extent that information is there, even if it's just a discussion with the sponsors to actually understand what the impact is on their business, that is an important information flow that needs to go to trustees to allow them to make an informed decision. The third point there is to avoid overcommitting to longer deferrals than may be necessary. And I think this ties back to the information point quite clearly, is that if there isn't visibility on what the impact will be, and there probably isn't for a lot of companies at the minute, then actually it's quite difficult to form a basis for agreeing to a longer term deferral beyond particularly the next few months. And it may well be that actually, rather than agreeing to a long-term deferral, what could be a more sensible option is essentially a series of rolling deferrals, which could be kept under constant review and ended should the need for deferral no longer be there. And then finally is around seeking protections, and Dan and Emily will come on to that in due course. I think there's probably a couple of points that are most interesting that are coming out of the discussions we've been having with a number of our clients so far. The first is really how to take a view on whether a deferral is actually needed. Now, there's probably a couple of ways of looking at this, and a lot of this will depend on philosophy and the context of the scheme, and also the relationship that trustees have with their sponsor. So obviously, it's possible to look at this in quite a strict sense, shall we say, which could be to look at a company's forecasts and quite a hard-nosed fashion try and understand if it's going to run out of cash or not if the deferral isn't made. Now, that's in some ways quite a simple test, albeit we appreciate understanding the inputs into that could be quite complicated, simply because of the range of impacts that COVID is having on sponsors, be it through their supply chain, be it on demand, be it on financing availability. But actually, it's, when you can reach a conclusion, it should be relatively clear or not whether the financing facilities will remain there for the sponsor or not. But perhaps there's another way of looking at this, which is perhaps a bit softer, which is that we're all in a bit of a fight together against the virus and against dealing with its impacts, and that actually providing all shareholders and all stakeholders rather are contributing towards that fight, then actually to what extent is it credible for the way. Now that's of course a bit more contentious, because you could also take the view that it's for shareholders to take the first loss and for lenders to provide lending capability. But perhaps if you as trustees are minded to take that slightly softer view, and I've heard some very sensible comments that actually relative to the market movements we've seen of the last few weeks and months, actually a few months of DRCs are not that significant, arguably, in some situations. Perhaps the key thing for trustees to think about is actually how will they benefit longer term from essentially providing a form of financing. For instance, could there be some form of interest or some change to the recovery plan to shorten it, just as a quid pro quo for providing support in the near term. So something to think about there. And I think that plays into the second to last bullet on that page of assessing whether a deferral is appropriate for the scheme. Perhaps what we'd encourage all trustees to do is to have a think about, is deferral better than the alternative, and conversely, actually is not agreeing to a deferral also better or not than the alternative, and it's trying to weigh up those two worlds and work out which is best for their members. And then the final point that we'd put in there is whether IRM guidance or all other guidance remains very relevant in these situations. Clearly the risk capacity of many sponsors is impacted in the near term, but also longer term as well. And I think trustees, what they will need to have a think about, maybe not the immediate issue, but certainly in due course, around what that change in risk capacity may mean for their scheme's journey plan and the balance of investment risk as well over time. So I'll leave it there, and I will now pass over to Emily, who will take you through some of the situations we're working on with our clients.
Good morning, everyone. This section is about our own experience and practical tips coming from our combined learning. As you'd imagine, we're doing lots of COVID-19 related work at the moment, and we're seeing plenty of requests for deferrals. Before I start, we've got another poll. Hopefully, thank you. So what do you think the long-term impact on your sponsor will be? No material long-term impact, lasting impact but survivable, potential future distress, or the short term is too uncertain to take a view on the longer term right now. Okay. So over half of you see the situation as too uncertain to decide right now. And that uncertainty is a real theme that we're seeing through all of our case studies. So it doesn't surprise me that that's the answer right now. So I'm going to talk through some case studies that I'm directly involved in. They're ongoing cases, so it's going to be on a no-names basis, very high level, really just to give you a bit of a theme, a flavour of the themes that we're seeing at the moment. So the first case, could we turn the slide, please? Thank you. So the first case, it's an industry-wide scheme. There's lots of employers. The amount that the sponsor is asking for is fairly small in the context of the scheme, and it's for a short period of time. But the trustee is keen to follow a proper process so that all employers are treated fairly, particularly as there may be future requests coming in from other employers. The next case is a covenant at the weaker end of the scale. It's in the relatively early stages of a turnaround, and COVID-19 is hit before it's really worked through that turnaround. The requested deferral wasn't a huge amount of money, but it was material in the context of the scheme, and it was for more than 3 months. The sponsor has since changed their mind and decided they don't want that deferral. But the thing is, the trustee has already seen the stress that the business is under, which brings up discussions around contingency planning and stepping up monitoring, for example. The next case study is a weaker covenant. It's an industry that's been hit very hard by COVID-19. In the middle of evaluation, those discussions are now on hold. The sponsor's taking all of the actions within their control, so furloughing, pay cuts, HMRC deferral, etc. But there's still lots of uncertainty. The proposal is for a deferral of more than 3 months, but given the uncertainty, one option that's being discussed is potentially just deferring for a short period of time until more information is available, and then looking at a longer term deferral, which links into the feedback that uncertainty is an issue. Another case that we're looking at is looking at a rolling 1 month deferral until more information is available. And then the final case study 4, again a weaker covenant, different industry to case study 3, but still very hard hit by COVID-19. Again, this business is working hard to cut their costs and to preserve cash. Their recovery plan was already affordability constrained, so there were already dividend restrictions in place and security in place. And what's being asked for is a very significant deferral request. It's for 12 months deferral. So in terms of that one, we're doing a fairly detailed review to understand the updated forecast, understand what other stakeholders are doing, whether shareholders are putting in money, for example. So from just those 4 examples, you can see there's quite a range of what's being asked for, the level of distress. A lot of the cases that we're seeing at the moment have underlying covenant issues even before COVID-19, which would make sense that the first wave of what we're seeing are those ones with a weaker covenant, but that doesn't mean to say that those with a stronger covenant may not follow soon after. So now I'm going to talk about process. So as Darren and Alex have said, market practice is being developed, and these situations are scheme specific. And as Alex said, it's not our job to tell you what your principles are. We see it as our job to work with you and your other advisors to understand the risks of accepting a deferral or rejecting a deferral, and to put in place a proper process so that you can document the approach you've taken. I'm going to walk through some of the more difficult questions from a covenant perspective now. So question 1, what is the underlying ask? It's important to be clear on the amount and the timescales, because that will help you decide on what's a proportionate approach to what you're being asked. There's a real temptation at the moment to ask for just 3 months because based on the regulator's guidance. But if it's likely to be more than that, and that deferrals are likely to be spread over a prolonged period of time, think about that right from the start. Also think about how material it is from the scheme's perspective. So think about journey planning, maturity, liquidity, those kinds of things. Question 2, does the sponsor really need to defer? So is the deferral critical to the survival of the business? We'd generally expect to see fairly detailed information to demonstrate how critical the deferral is. Think about what would happen to the business if those contributions weren't deferred to help inform that discussion. In some cases, we're seeing cases where The deferral's just to prudently build up some liquidity against a particular downside scenario that the business is concerned about. So sometimes it might be that the deferral is nice to have rather than necessary. Again, that should inform your thinking. And also think about whether the deferral needs to be for the full amount and for the full time. It may be more appropriate for a smaller deferral over a shorter period of time, linking back to what Alex said about not overcommitting to longer term deferrals. Question 3. So this is the one that came out through Alex's poll. Is the scheme being treated equitably? It's a key theme from the regulator at the moment. So think about how other stakeholders are being treated. So lenders, employees are seeing a lot of pain at the moment with furloughing and pay cuts. Other schemes, other creditors. Shareholder support is always a thorny issue, and more so now. The regulator's been focused on dividends versus DRCs for quite some time. We'd generally expect shareholders to take some pain before creditors, and there's clearly an expectation that dividends are not paid until deferred contributions are caught up. But that's easier said than done potentially if there's a difference in the payment profile. So if you've got quarterly DRCs and annual dividends, you may find that the scheme's being asked to take pain before the shareholders are. In some cases, particularly more distressed cases, it may be appropriate for shareholders to be putting money into the business as well. In terms of government support, most sponsors are doing all they can to access all the government support that they can, but that gets a lot more complicated with a global business. So how well do you understand furloughing rules around the world, for example? Question 4, how is increased credit risk being addressed? So deferral of contributions is increased credit risk, and this is all about downside protection. I'm going to be fairly high level because Dan's going to talk about this in a bit more detail further on. But security is the most obvious form of downside protection, and we're seeing it in a number of cases, even some short-term deferrals. You may not expect to get it, but it's worth asking for it, because if you don't ask for it, somebody else will. Deferral also means lost investment income. So are you getting interest to cover some of that lost income? It makes sense to link downside protection to contingency planning, but if you've not done that contingency planning, that's relatively hard. And Dan's then also going to talk about contingency planning. And the final question, question 5, can the sponsor survive this? This is a really tough question, and we're not talking about gazing into a crystal ball. This is about doing the work to understand how stressed your sponsor is. So will cash run out in the downside scenarios? What's the cash requirement to ramp up post-lockdown? For example, has working capital been stretched? Have HMRC payments been deferred? All of that needs catching up at some point. And all of this links back to downside protection and contingency planning, which Dan is going to talk about. So there's naturally some tension between these questions. If the deferral is absolutely critical to the survival of the business, is this really just about the short term? And how confident are you that your sponsor is going to survive? These are meant to be difficult questions. They're meant to challenge your thinking and help you document a really robust process. And on that note, I'll hand over to Dan, who can talk about contingency planning and downside protection in a bit more detail.
Thank you, Emily, for that. When we talk about protections, the way I look at it, my understanding of it is really about risk management, as Emily's alluded to, and making sure that ultimately members' benefits are protected. And that can be done in a number of ways, in tangible ways, some of which Emily's alluded to, and intangible ways. And of course, everything's going to be scheme specific. So there's a big difference between a scheme that had a very strong covenant sponsor before this outbreak of COVID-19, where the scheme is actually quite small and well funded, compared to a scheme where the covenant was weak with big DRCs to try to rapidly make up very large deficit. So everything will be viewed by you in the context of the particular sponsor. And all the decisions, of course, you make must be done with that in mind and must be proportionate. There's no point going in with a long list of demands that you know that are unrealistic and not really necessary. This is all part of the risk management, is also making sure your relationship with the sponsor stays as strong as it can be in these circumstances. So Emily's talked about some of the things that you can get which are tangible. Security being an obvious one, which may or may not be available, particularly if there's already a secured creditor in there. There may not be many things available to be secured. You can talk about cross guarantees, parent company guarantees, if an overseas parent not quite in the same position. One, I think, which is quite plausible to get in most circumstances is negative pledges. So at least if you don't get anything, nobody else will. So, you know, a trade creditor or somebody else who hasn't got security won't be able to jump over you in the queue. And we talked about loss of compensation for lost investment returns as well, which I think is important. But as important, if not more important than these tangible protections, are the intangible protections, which I categorize as flexibility and information or knowledge. Alex alluded to the importance of flexibility, and I think Emily mentioned it too as well, that rather than necessarily lock yourself into a fixed deferral period, if it's 3 months or 12 months, have the ability to constantly review and have the option to change the situation and change your decision. Flexibility is key. Over 50% of you have said that you're very uncertain about the future of the sponsor. And of course you are. Nobody knows the future of anything at the moment. And therefore, it's very important to be nimble and on your toes and be able to make decisions in real time as facts change, and they will change very quickly, no doubt. So it's important that you are not locked down for fixed periods. And just as importantly is information flow. Some of you will have sponsors who are quite used to sharing information, and you've got that relationship. Some of you don't. So certainly some of our clients, they're not used to giving anything other than public information. It's a real bind to get it out of them. A request for a deferral contribution, a request for a deferral of contributions is a great opportunity for you to say, look, that's fine, and we want to be supportive, but we now need to have real-time information flow so that we can understand the situation. We're talking about things like short-term cash flows, monthly management accounts, key performance indicators of a particular business, so you can see how it's going on a month-to-month basis. I mean, I completely appreciate that you may want to be supportive and you don't want to feel that you're burdening a CFO and his colleagues who will be fighting numerous fires. But first of all, they're probably going to be producing this information anyway internally, but also it's fundamental that you get this so that you are on top of the situation. And it's very important that you think about not just the short term and what's going on, but what is the longer term here? Has the company got a fighting chance of getting out of this? I know you won't know the answer now, but it's something that you need to think about and concentrate on. And you know, if it helps, think of yourself as a lender in this situation. A contribution deferral is effectively lending, and therefore come at it as if you were a bank. A bank would be demanding information. And there's no reason why you shouldn't put yourself in the same shoes. And if there is a bank there already, make sure that you're getting the same information as them. It's not uncommon in a stress situation or restructuring situation to have the trustees in that position, and therefore you should reflect, call it the leverage that you have now to get that information. But it's really important for you to have it. I can't reiterate it enough because you need to be nimble in this situation. And we talk about contingency planning, and we're going to have a webinar on that in the next few weeks. So I don't want to spend too much time going through that, but really the concept is that it goes back to the information. If you think that the sponsor is particularly distressed, and by definition, if a sponsor is requiring a contribution holiday, otherwise it won't have enough liquidity, there must be some distress, even if it is the short term while the virus is out there. Therefore, you should be thinking ahead. What is it that we need to think about could this possibly go through some sort of restructuring, or worst case some sort of insolvency event? Have we got our ducks in a row? What might that mean for us? And this is the time to start thinking about it. But as I said, we will try and explore that in another webinar. So to conclude, I think it'd be helpful just to go through everything we've done, mentioned already, and we call it the 3 Ps. First one being principles, which Alex set out, which is really be prepared to help the sponsor. That's what everybody's disposition will be, but make sure you follow the guidelines that the regulators have set out. Process, as Emily covered, which is really make sure you, whatever conclusions you come to, make sure that you set out the facts and the advice that you've taken and all the basis for your conclusions, and have them on record. And then the last point about protections, it's really understanding and managing risks appropriately. As Darren said at the beginning of the session, in the next week we'll make available our decision tree for all of you to look at, which we think will help you in your approach examining any such requests. I think we've got time for one more question. And it's who's prepared contingency plans should, in the event that their sponsor becomes distressed. So the options are contingency plans are already prepared and formalised. They've been discussed previously but not formalised, currently being developed, or situation too uncertain for contingency plans to be helpful. Do we have some results? Oh, not surprisingly, given the answer about uncertainty about the future, biggest answer, although less than 50% saying it's uncertain. Look, the important thing is to get that information flow through, and as things develop, keep revisiting the need for it. Okay, well, thanks. I think that concludes the presentation element, and some time for some questions. Let's see if any have come through. Bear with me. First one, I think, which I'll hand over to Emily, is have we seen any refusals?
So I haven't seen any refusals. I'm not sure if the other guys have.
Darren, off mute.
There we go. I think we're in the middle of it at the moment, and certainly there are a number of trustee boards that are considering a refusal. And I think when first the TPR guidance was released and some of the proposals were made, there was a sense or a perception, rightly or wrongly, that effectively some kind of permission had been granted for 3 months. And I think the other piece was the prevailing narrative at the time was this was a 3-month problem. We were around the time, if we can remember, not so long ago, when we were talking about 12-week lockdowns of maybe the at-risk group. We're now into the second phase of a rolling 3-week lockdown of pretty much the whole of the nation. And what was then a 3-month issue is becoming a longer issue. So the time frame is very uncertain. I think what happened is some of the initial requests were made, a few weeks ago, as finance directors looked around and started pulling on all the levers, HMRC, furloughing, as part of a natural reserving and cash piling policy. And then what's happening, as we've explored in this session, is when you actually look at the data on a case-by-case basis, there are many instances where the maths doesn't actually suggest, or the economics doesn't suggest, that a deferral of DRCs is needed at all. Now, as Alex said, one can then get into the space where one says, okay, well, we should just say no to this request. And understandably, perhaps saying no is quite hard to do. And one starts to think about the sponsor relationship, and one starts also to think about whether or not that's a credible position with all the other management actions that are being taken. And that's leading to some trustees thinking, in certainly cases I'm working about, saying to the sponsor, we don't really see a need for it right now, but here you go. This is the sort of what we would need to see for us to feel it was necessary. And also, here's what we would need to be put in place to agree to it. So we're not so resolute that we won't ever do it. But just so you know, these are the sorts of conditions we would expect to see. These are the sorts of protections we would expect to get. And sometimes that's leading to some discussion around, well, maybe I don't want you to defer now. I think there's a case you're referring to, Emily, where in effect the deferral request was rethought about by the sponsor and withdrawn. There are some cases where we're working on where deferral of DRCs is not a victimless crime in the sense it's an easy, because the maturity profile means that there will need to be some disinvestment of assets to start paying pension and payroll and some of those aspects as well. So a bit of a long answer, but to say that we've got a number of trustees who may well, let's say, a version of no, which is, here's what we would need to see for us to agree. And in that circumstance, effectively, it remains to be seen whether in 6 months' time, 3 months' time, 1 month's time, they would need to defer at a later stage.
Thanks. There's another question, which I think I'll take, which is a question about whether actually a constant review, which I think I referred to in my section of information, is realistic. And actually, should it be less frequent, perhaps monthly or even quarterly? There's a challenge to advisors and the regulator around that from the questioner, which is fair. And I think the answer is, of course, it's going to be scheme specific. I think depending on the nature of your sponsor and the business that your sponsor is in, and your understanding of that industry, will dictate how much information you need. It might be that it's realistic to see how they're going to cope with the situation, and they it's relatively stable. There might have been some impact from COVID, which people are quite happy to understand. There's some pent-up demand that should be released depending on the industry that they're in, and you can see a clear path. If there's some real-time issues that are happening though for your sponsor, there are some perhaps KPIs that are coming up that need to be looked at, or there's some changes in the environment going on around us, legislation or events, then you can up the ante and up the information flow accordingly. So I accept this is not supposed to be a one-size-fits-all session and piece of advice. We're trying to capture all eventualities. I hope that answers that. There is another great question here, which I'll throw to Darren because it's a doozy. If your scheme is below the PPF funding level, is it legitimate to take the view a deferral is a one-way bet? If the business survives, great, but if not, PPF and all other schemes pick up the tab. Discuss.
I think we need some legal advice for this one. And this would be a case where I would phone a friend and also talk with the law firms that we work very closely with. It sort of feels like one could be getting into some kind of dangerous territory there. I think commercially and economically, it's a very good point, and it's a great point. I've been sat in many trustee meetings where that sort of one-way bet issue arises, and it's when the sort of many experts or law firms and independent trustees sort of pipe up and remind us that we can't really gain the PPF in that way. But subconsciously, it's a fair point. it's a fair point and probably changes the complexion in a good number of situations. I saw on the questions, Dan, another one which I'll take briefly, which is around whether what's happening now may impact the regulator's approach to introducing its new funding code. And those will remember, in the wake of the financial crisis, the regulator received effectively a new statutory duty, which was to sustain sustainable growth of sponsors, and therefore to sort of balance perhaps the sort of member and trustee objectives that were already in TPR's statutory duties. And I think that, given the severity of this crisis, some of the provisions, again, well intended, and the new funding code and the new funding regime that was anticipated for Q1 2021, maybe it is necessary to work through this crisis effectively under the flexibilities of the existing regime, which people are familiar with, people understand, contains the sort of sustainable growth objectives and some of those features that worked through the last financial crisis, rather than finding that we move into a new regime with the sort of new approach there. And what I understand, that seems to be something that the regulator is quite actively considering in terms of whether it should alter the timeline of the new funding code and new regime.
Thanks. I've seen another one which I think I'll have a go at. I've seen senior management taking pay cuts to demonstrate equality in treatment alongside DRC deferral requests in certain situations. Do you see this as a nice to have or a should have? Now, it's interesting, and I think, again, it's going to depend on the level of pay these executives have. I think bonuses should be certainly frozen as part of your agreement to request deferral. But I don't know that trustees, in my view, should spend too much time thinking about basic pay of executives, even if it's at the sort of higher end, if it's not obscene, because one doesn't really know what commitments they have. I think it's more for executives to justify to the workforce if they're being furloughed and asked to take pay cuts, rather than necessarily be the biggest issue for a DRC deferral. But it's going to be interesting depending on the size, and it's a question certainly to ask. Can certainly ask, but whether it's a must-have, I'm not so sure. It will be. One maybe for Alex, actually. Do we recommend informing the regulator whenever the trustee gets a deferral request?
I think there's probably a couple of things there, and I think really it will come down to the specifics of the scheme and the context and the relationship it has with the TPR. If you were to think about maybe two specific elements here, first of all is if the regulator has an ongoing engagement with that scheme, then it would seem like something to think about is whether you at least give the regulator a bit of a heads up that, by the way, this is coming, because there's a good chance they're going to know about it anyway. I think the approach we've seen from the regulator so far in some of these situations has been relatively light touch rather than necessarily wading in, because clearly there's a lot going on and trustees need to do as they will. The other point here is I think that there's a question about actually how are some of these deferral requests getting documented. We're seeing some being done by side letters. We're seeing some being done through schedules of contributions for changes. And my understanding is, particularly where schedules of contributions are getting changed, then actually those will get submitted to the regulator in due course anyway. I don't think there's a need necessarily to go out and tell the regulator every time one of these comes in, because there's a lot of these coming in and trustees will need to look at them by themselves. But clearly there are some situations where, as part of an ongoing dialogue with the regulator, if there is one, then it might make sense just to keep them in the loop.
Thanks. Do we have time for one more?
We're just on time, I think.
I'll throw the last one in. Maybe Emily, you can start and see if anyone else wants to build on it. Can we comment on whether the situation is different where trustees have additional powers, for example, set contributions?
Yeah, so in one sense, it's no different because you've got the right to be paid the deficit contributions that you're due, so that contribution setting power shouldn't make a difference. But on the other hand, if you've got a situation where there's a risk of distress and you're doing all of your contingency planning, having that contribution setting power becomes really important, because if the sponsor fails and you didn't use that contribution power and you could have used it to get a better outcome for members, you may need to justify your position. So the contribution power is something to have in the background whenever you're looking through these kind of situations and whether you should be using it. So it's certainly relevant, although a simple question of deferral wouldn't be that different. It's the wider picture that's more relevant.
Thank you. Okay. Shall we leave it there? Thank you, everybody who's joined. I hope that was
Yes, thank you very much.
interesting.
Thank you.
Thank you again all for your time. I really appreciate it. Have a good morning. Bye-bye.